bill of hundreds of thousands. Yes, I remember that. Okay. Well, but I think generally, look, I mean, I was thinking about this morning, and I thought I should just tell you that, I'm by no means the leading authority on these issues. I can only convey to you my experience and my interpretation of the rules and the case law and the procedure. But possibly very soon, I'm going to have to be arguing before one or more of you, and you're going to be the ones making the decision. So my purpose here, and please understand that, is to guide you through the process so that you can educate yourself, and that's what's going to be expected of you. Because essentially, I'm going to be wanting to argue one case or one side, and I'm going to have an opponent who wants to argue the other side, and at the end of the day, it's up to you to make the decision. So read for yourself. Don't necessarily believe everything everyone tells you, including me. Well, believe it or not, and I won't tell this to my husband, but I also make mistakes. So never admit it to him. But so please know that through this training, this is not supposed to be the be all and end all. This is supposed to be an introduction to civil procedure in the High Court, and it's supposed to give you a platform from which to lift yourself to the level that you need to be in order to practice as a High Court judge. So please bear in mind that what I'm telling you here is not cast in stone, in the sense that you have to make up your mind on many of these issues yourself. And many of these issues are difficult and complex legal issues, even when it comes to procedure. And you will have to develop the ability to know what to do in circumstances where it becomes complex. So I'm trying to, on a very basic level, just introduce you and really navigate you through the process so that you at least have an understanding of what's happening. All right. So that takes care of suspectus de fuga. We have another matter that we were promised that you bring.
Yes.
Okay, so let's have a look at that. Just remind me, what was that about again? That was the
It was about
adultery.
and claim against third parties.
Alwyn van Straten. Surely he didn't sue for adultery. Which paragraphs in this Alwyn van Straten matter do you want to refer to?
Actually, that one is proceedings. That one is the whole issue that we were discussing yesterday, the whole case. But then the other one, the Supreme Court judgment one, I can't remember the paragraph.
Okay, but the van Straten matter, it was an urgent interdict. What's the relevance of this matter to our discussion?
That one was it was actually a third party claim. That is out from the.
Well, not in adultery. Not in this doesn't have to do any. This doesn't deal with. Alwyn van Straten is a liquidator.
There is another one. Who is the
This was an eviction.
beggar?
Yeah, this is the other one. You handed me two matters. This is Sibonga versus Chaka.
Okay. Then I think I made the wrong. I copied a different one.
Okay, so this one I suppose hasn't got anything to do with what we discussed, because that was an urgent interdict. Mr. van Straten is a well-known liquidator, and that was an urgent interdict for eviction. Okay, so this is Sibonga. It's a 2014 matter, so it precedes the judgment by Judge Witele, if I'm not mistaken. Let me just, let's see. Yeah, 19 August 2016. That was for loss of, let's see. Okay, so it says in paragraph 13, the issues to be determined by this court are thus whether the first defendant could give evidence against the plaintiff in respect of the claim against the second defendant, and secondly, whether the claim itself is sustainable in law. And then the further question as to punitive cost order, which we won't. Then the ruling on marital privilege. So you know what marital privilege is. I don't need to explain that to you. So a spouse cannot be forced to testify against. I can't be forced to testify against my husband. We, while we're married, and even after, we have, during our marriage, we are protected in terms of the Civil Proceedings Act. by privilege between spouses. Okay, then whether the delict of adultery is still sustainable in law. The question posed by this court concerns the continued existence of the delictual action of adultery. A similar question was coincidentally also Miramoto posed by the Supreme Court of Appeal in RH versus DH. The reference is there in paragraph 24. And then they referred to the context within which the question was asked in the Supreme Court of Appeal in South Africa, which is the context in which the question arises is the recognition by our courts that while the major engine for law reform lies with the legislator, the courts are nonetheless obliged on occasion to develop the common law in an incremental way. These occasions are dictated firstly by section 39(2) of the Constitution, that's of course the South African Constitution, which imposes the duty on courts to develop the common law so as to promote the spirit, purport and objectives of the Bill of Rights. So that would be the same objective in Namibia. So courts would have a duty to develop common law in keeping with so for instance, insofar as the spectus de fuga is still a relevant remedy in Namibia, courts are expected to develop that and develop case law that's in keeping with the Constitution and consider whether such relief is in fact still relevant. Then they deal with the boni mores of society, etc., etc. And they say, in the more recent past, our courts have come to recognize, however, that in the context of the law of delict, the criterion of wrongfulness ultimately depends on a judicial determination of whether, assuming all the other elements of delictual liability to be present, it would be reasonable to impose liability on a defendant for the damages flowing from specific conduct, and that the judicial determination of that reasonableness would in turn depend on considerations of public and legal policy in accordance with constitutional norms. So they say this court has affirmed this approach in the context of the determining wrongfulness in delictual claims, and of course the kind that one has in adultery and claiming against a third party is one in delict. Then they deal with the role of the common law. Let me just try and find where they deal with the issue. Okay, so it seems to me that this issue wasn't dealt with in the High Court in this matter, because they say in paragraph 32, although this court is at a disadvantage considering an issue when not dealt with by the High Court, it can and does happen that issues are identified on appeal for the first time by this court, which needs to be addressed in argument, giving the parties adequate notice to prepare both written and oral argument on an issue. As occurs with other courts of appeal, okay. Public policy also informs the element of wrongfulness in delictual liability. This was acknowledged by this court in the context of the Aquilian action. The inquiry is thus whether the act of adultery is wrongful for the purposes of the delictual claim in question, as was also posited by both the Supreme Court of Appeal and the Constitutional Court in DE versus RH. That's the matter, the South African matter they continuously refer to. If not, there would be no delictual claim without wrongfulness. So it's whether the adultery was wrongful. As I've said, the element of wrongfulness is determined with reference to the legal convictions of the community and public policy, which is now informed by our constitutional values and the changing nature of the prevailing norms of society. This inquiry is ultimately whether public policy means that a claim founded on adultery should still form part of our common law. This court is in a position to make determinations on public policy. The common law context and nature of the inquiry, being a dispute between the plaintiff and the second defendant, does not require an input from the Attorney General. It would in any event not be apposite. Even where a common law rule has been challenged on the grounds of being in conflict with the Constitution, that has not been found to be necessary or apposite. That's just when you have to join the Attorney General. You know that when you're taking on a statute for being unconstitutional, you need to join the Attorney General. What they're saying here is when you changing the common law, it's not necessary to join the Attorney General. Okay, let's see what they say. They deal with what is in the Supreme Court of Appeal Action DE versus RH. Okay, then they deal with the High Court in Van Wyk versus Van Wyk. Noted a softening of societal attitudes to adultery in this country. Then they deal in paragraph 42 of that judgment with Van Wyk versus Van Wyk. I'm just trying to find where they actually come to a conclusion. Okay, so which is important to keep in mind in 49 of the judgment, as in RH versus DE, the plaintiff in this matter would appear to have been motivated by vindictiveness and anger, looking to the second defendant as a scapegoat for that anger. The actual award for damages would hardly justify a lengthy High Court trial. In this case, the plaintiff had, both in his pleadings and in evidence, admitted his own adultery, even after or even at the time of the breakdown of the marriage. But ultimately, in its respect of the determination of, it is in respect of the determination of wrongfulness, with reference to the legal convictions of the community informed by our constitutional values and norms, that it is no longer reasonable to impose delictual liability for a claim founded on adultery. Whilst the changing societal norms are represented by a softening in attitude towards adultery, the action is incompatible with the constitutional values of equality of men and women in marriage and rights to freedom and security of the person, privacy and freedom of association. Its patriarchal origin, perpetuated in the form of the damages to be awarded, are furthermore not compatible with our constitutional values of equality in marriage and human dignity. And then they again deal with DE. That seems to be me, this DE versus RH matter we should go and read, because it appears to me that it's very relevant. So the conclusion I reach is that the act of adultery by a third party lacks wrongfulness for the purposes of delictual claim of contumelia and loss of consortium. Public policy dictates it is no longer reasonable to attach delictual liability to it. The action is thus no longer sustainable. This is a judgment written by Smuts, and did Shivuten Mainga concur? Concurring, yes. So there you have it. Thank you. So if you want to go into the practice of divorce law, then don't sue the third party. Okay. That doesn't change anything that we did yesterday regarding divorce law before you as on an action. I mean, we didn't deal with third-party claims. So please be mindful of that and of the situation that has changed in Namibia. All right, good. Anything else that we discussed yesterday that we wanted to speak about today? I think we've got everything. Good, thank you. All right, absolution from the instance. So I'm jumping. Sorry, we are here. So I'm going to deal with absolution from the instance. It's one of the only issues I'm going to be dealing with here. I just want to deal with that now under pleadings, so that we can finalize that part. It's actually something that probably falls better under trials, but we don't have a specific section for trials in this session. All right, so absolution from the instance. Can anyone venture an explanation as to what absolution from the instance is? It's strictly speaking, it's three instances. It's either at the trial if the plaintiff doesn't show up. It's at the end of the close of the plaintiff's case before the defendant has opened its case, or at the end of the trial. So you have three instances where you can actually apply. It's more often than not actually only applied for at the close of the plaintiff's case before the defendant opens its case. Now, so it's either at the start of the trial where the plaintiff doesn't show up. You can seek absolution. So they haven't made out a case. or it's at the close of the plaintiff's case, mid-trial, before the defendant has opened its case, or it's at the end of the trial. Okay, so it's either at the beginning of the trial, if the plaintiff doesn't show up, so it doesn't present evidence, or at the close of the plaintiff's case, before the defendant opens its case, or at the end of the trial. It depends whether you're seeking absolution or whether you're seeking a dismissal, because so it doesn't matter. On absolution, the test is the same. Absolution is absolution, irrespective of when you seek it. Once you've closed your case, I can hardly think that you would want to seek absolution. You'd probably want to seek a dismissal, but it might be for certain reasons that you seek an absolution. So essentially, absolution in this jurisdiction is normally sought at the close of the plaintiff's case, or at the start of the trial. I mean, absolution and or default judgment, depending on tactically and strategically where you are at that point in time. If you seek absolution, it doesn't matter when in the proceedings you seek absolution, the test will remain the same. It depends whether you're seeking absolution or whether you're seeking a dismissal, sort of a final, this is now the end of the matter, because the test differs significantly between seeking absolution and seeking a dismissal. Okay, it's obviously more difficult to get absolution than it is to get a dismissal, for the simple reason that the test is a low threshold test, in the sense that for the plaintiff, in favor of the plaintiff. But I'll deal with the test now and the principles relating to absolution. It's exactly because the court hasn't heard evidence. So the plaintiff is there, its case is set down for trial. It's exactly the same thing. So what you would say to the court in absolution is there's no evidence or sufficient evidence on, when you deal with the test, you'll understand, on which a reasonable court might find in favor of the plaintiff. So there's no evidence, so I'm seeking absolution from the instance. That's why you can do it if there's no, if the plaintiff gets up and says, it may as well happen, the plaintiff may say, I close my case because on the pleadings this is in dispute, or this is in dispute and this is not in dispute, and given what's in dispute on the papers, I close my case without leading any evidence. It's happened. It may be then that you may seek absolution. Similar situation. So if the plaintiff doesn't show up, you can seek default judgment, or you can seek absolution. You're entitled to seek absolution because no evidence has been presented on which a reasonable court could find in favor of, might find in favor of the plaintiff.
Okay, let's say the court grants absolution, and the other party appears at the later stage. What happens now? Can the court rescind its own judgment? We're
getting to that. So maybe hold those questions until the end. You may find more clarity when I'm done with the topic.
All right.
Okay. So before we deal with the principles of absolution and the test, the effect of an order granting absolution doesn't mean it's the end of the line for the plaintiff. So it means that a plaintiff against whom absolution has been granted can come to court again. So the doors of the court are not closed. It's not a res judicata issue. The plaintiff, if it can bring other evidence, can come to court again. Okay. Which is why, as in my practice, I tend to not want to seek absolution. If I think that if I'm confident, and it's happened once or twice, if I'm confident that I will get absolution from the instance, I simply get up, close the defendant's case, and seek a dismissal without leading any evidence, because I want it dismissed. Okay, because there's a big difference. If it's dismissed, it's over and done with. I've closed my case, everyone has had their say, even though I haven't presented an evidence at all. But there are instances where you want to get absolution because you're not sure that you'll actually get a dismissal. Okay, so that really depends on the practitioners. It's unfortunately something that's becoming par for the course, in the sense that if you're in a trial and the plaintiff closes its case, more often than not the opponent gets up and says, I want to apply for absolution. It's something that unnecessarily leads to delays. It's something for which extempore judgments should be given, in my in my view. It's something which parties, defendants abuse in order to get a postponement of a matter in a sort of an indirect fashion and prolong the inevitable. So when it is properly used, it's a very effective tool. When it's abused, it really only leads to delays. And irrespective of a cost order, it's interlocutory, although there's authority to say it's not interlocutory and therefore Rule 3211 doesn't apply, but I mean that's probably still debatable. So essentially it's important for a judge to know when it's abused and when it's not being abused. Right, test for absolution. Our Supreme Court in the matter by Acting Judge of Appeal Mtabanengwe in Stier and Another versus Henke. The reference is Volume 1, Namibian Law Reports. Where's the here? I must have. I'll check the 2012. Thank you. Volume 1, Namibian Law Reports 370, page 370. At page 373C to I, he set out the test for absolution, which is accepted, and this is really a tried principle. It's with reference to the Claude Neon Lights matter. I think it's not in this. Okay, anyway, Claude Neon Lights. It's referred to in the Stier and Another versus Henke matter, so you can have a look at that. Because Claude Neon Lights, South African matter, appellate division of 1976, and in that matter really is the tried principles were set out and it was accepted and applied in our jurisdiction, and they are the following. When absolution from the instance is sought at the close of the plaintiff's case, the test to be applied is not whether the evidence led by the plaintiff establishes what would finally be required to be established, but whether there is evidence, and this is why answering your question about why if no evidence was led can you seek absolution, but whether there is evidence upon which a court, applying its mind reasonably to such evidence, could or might, not should or ought to, find for the plaintiff. This implies that a plaintiff has to make out a prima facie case in the sense that there is evidence relating to all the elements of the claim to survive absolution, because without such evidence, no court could find for the plaintiff. As far as inferences from the evidence are concerned, the inference relied upon by the plaintiff must be a reasonable one, not the only reasonable one. The test has from time to time been formulated in different terms, especially it has been said that the court must consider whether there is evidence upon which a reasonable man might find for the plaintiff, a test which has its origin in jury trials when the reasonable man was a reasonable member of the jury. Such a formulation tends to cloud the issue. The court ought not to be concerned with what someone else might think. It should rather be concerned with its own judgment and not that of another reasonable person or court. Having said this, absolution at the end of the plaintiff's case, in the ordinary course of events, will nevertheless be granted sparingly, but when the occasion arises, a court should order it in the interest of justice. Okay. A plaintiff is required to present evidence to support every element of his claim as set out in the pleadings. I can refer you to Supreme Court of Appeal matter in South Africa. That's Gordon, Lloyd, Page and Associates versus Riviera. The citation is 2000. I'll provide a complete list of all the case law tomorrow or Thursday to Lorraine to circulate to you, but you can write this down. 2001, Volume 1, South African Law Reports, page 88, Supreme Court of Appeal at page 92. So there it's set out that a plaintiff is required to present evidence to support every element of his claim as set out in the pleadings. So therefore, to answer your question earlier, when a plaintiff doesn't pitch up, his pleadings are before court, the matter is set down for trial, the defendant is entitled to accept that there's no evidence before the court, and therefore there's no evidence to support the particulars of claim, and therefore absolution is competent. I would not move for absolution then, but you can. So your question is probably more directed at whether it's from a litigant's point of view, whether it makes sense to apply for absolution, then probably not. And whether I would depends on the circumstances, but you are entitled to do that. And you're entitled to do that because there's no evidence before the court based on which the court then may find in favor of the plaintiff, might find or could find in favor of the plaintiff in respect of all the elements. All right, so at the close of the plaintiff's case, it must be inferred that the court has heard all the evidence for the plaintiff and that any further evidence that would be forthcoming if the case was to continue would only be to the detriment of the plaintiff's case. That's Erasmus Superior Court Practice at B1-293. So essentially when the plaintiff has closed its case, the court must assume that's the high watermark for the plaintiff. Nothing else is going to support the plaintiff's case. This is for purposes of absolution. Okay. So when an absolution order is granted, it means that the plaintiff can come again. The doors of the court have not been closed to him. It may be that that you won't be able to apply if you need to close your case, you may be in a different position. I can't fathom all the circumstances. It really, from your perspective, doesn't matter. It's from a litigant's point of view. So it really is for the litigant to decide whether he or she wants to apply for absolution in the circumstances. So they would strategically, from a litigation point of view, say it's better to apply for absolution or to apply for... I wouldn't apply as a practitioner for absolution where I'm sure that I'll get actually a dismissal. I wouldn't, because of that reason. But the thing is, there are instances where, and of course, if you only apply for absolution at the end of the defendant's case, or you may still grant absolution, which means that you will be mulcted in costs. Yeah. And remember, if you are not certain that, and this is just one of the considerations I've had in my practice, so I can only share with you my personal experience regarding absolutions and dismissals. If, for instance, you are not certain that you will get a dismissal, and if you're not certain about that, and you also don't want to call witnesses for the defendant because you fear that that might actually support the plaintiff's case, then you're in a bit of a pickle, because if you close your case nevertheless, the issues are done and dusted. You can never revisit them. You've had your chance. You've taken the decision not to lead any evidence, and you just have yourself to blame. In that instance, you may want to rather apply for absolution and hope that the plaintiff says, well, I don't have better evidence, I'm not coming back. So that is an instance where, for instance, I have in the past applied for absolution instead of proceeding because I'm not sure the witnesses, especially external witnesses, they say they will support the defendant's case, but I fear they may also make concessions under cross-examination, which will support the plaintiff's case, so I don't want to necessarily bring that evidence before court. That's a decision a litigant needs to make. So, because the plaintiff has the responsibility to call witnesses to support his case, and of course the defendant has no responsibility to support the plaintiff's case by way of evidence. So it's really a strategic issue, but there are instances where you will have to apply for absolution instead of proceeding with your case. So at the end of the trial, the court, on a balance of probabilities, decides. So it's a higher threshold test for the plaintiff. So what you would have, if I can refer you again to the authorities, Stier and another versus Henke, it's whether the court should or ought to find, not could or might. So it's a more difficult test for the plaintiff. It's easier to survive absolution. It's more difficult to survive at the end of both parties' cases. So if the lack in the evidence is so glaring that there's no way, or a specific necessary allegation has not been supported by any evidence, then court wouldn't find at the end of the defendant's case, even if no further evidence is laid. And then, of course, so it's a more stringent test for the plaintiff and a more relaxed test for the defendant, if I can call it that, whereas at absolution, the court would be more lenient. So it's could and might, not ought or should.
So in the event that none of the parties apply for absolution, can the court on its own, let's say for example at the end of the plaintiff's case, Meromutu make such an order?
I've had an instance where the court has said that it should have been absolution. I didn't seek absolution. You need to make application. I didn't seek absolution. The court found that we should have instead applied for absolution, and therefore the end of the case it was dismissed. But we were only so it has a cost implication. The court won't grant absolution if I proceeded and stated the case and the court has heard the merits. The court might then say, well, you should have actually applied for absolution, and as a result of that, I'm not giving you costs past absolution stage. That has happened in a case that I've acted in.
Now, in the event that you make an application, but it's not successful, can the court impose costs on the plaintiff?
On the plaintiff?
Yeah.
Why
if
would
the application is not successful?
No, but the plaintiff won't make application. The defendant would.
Yes, sorry. Yes.
Yes, absolutely. Yes.
At that stage.
Yes. Absolutely. And in fact, as a plaintiff, if a defendant applies for absolution and I oppose that, of course, as representing the plaintiff, I would insist on a cost order, that the application be dismissed with costs. And if absolution cost orders are given, I mean, it's a balance. You don't want to deter parties from seeking absolution in instances where absolution is apposite, where they should be seeking absolution. But you also don't want parties to abuse this just to delay justice, just to delay the issues. And in the second instance, one would expect that the courts would be more strict with cost orders, to say, well, I'm going to give a special cost order because this was a clear abuse, and that would be within the discretion of the court. So, well, I mean, granted that it's sought, but anyway. So, I'm just saying that it's a difficult balancing act, using costs to deter parties from abusing the process, but not using costs as a means to disencourage litigants from ever seeking absolution, because there are a number of instances where absolution is a very handy tool. Does that make sense?
Yes.
Okay. Any more questions on absolution from the instance? Okay, good. Then close of pleadings, which is the last one of the topic of yesterday, which I want to deal with, and then we can take a comfort break. So close of pleadings is called litis contestatio. That's just, again, a very fancy Latin term to refer to the close of pleadings. You'll find reference to that in Rule 51 of the rules. It is any party joins issue without alleging any new matter and without filing further pleadings. So, for instance, if there has been a, let's say, so there's been a summons, there's been a plea, and then this was 15 days, the court said in the case plan, and then there was another 15 days for a replication to the plea. This was filed, this was filed, this wasn't filed. 15 days expired, nothing happens, you're not obliged, you must file a plea. You're not obliged to file a replication. In many instances, you don't have to file a replication. So this wasn't done. Nothing happens to the plaintiff because they haven't filed a replication. They don't need to file a replication. It's only that they're given the opportunity in the case plan. Then it means that when the 15 days expired, close of pleadings automatically happens. Because what has happened is once the plea was filed and nothing was done further, it means that the plaintiff has joined issue with the plea. In other words, it says, these are then the issues. I agree that these are the issues between the parties. I have nothing more to say. Therefore, close of pleadings have happened. You follow? Does that make sense? Okay, that's one instance. If that's the last day for filing a replication or subsequent pleading has expired and no such pleading was filed. That's really, I suppose, this is actually more example 2. Example 1 is either you haven't filed a plea or you haven't filed a subsequent pleading after replication, because you, as you will remember, you still have rejoinder and rejoinder. So you haven't filed anything after the replication. So this would be something that the defendant files, and this would be something that the plaintiff files. This would be filed by the plaintiff. So it's plaintiff, defendant, plaintiff, defendant. Same with counterclaims. So the question is, I suppose, a more complex question, and I'm not sure that I know the answer necessarily. What about an instance where you have a main claim and a counterclaim? So do the pleadings close at the same time? Do they close at different times? So what you're saying is the main claims papers, let's say that we are here with the main claim. Replication was filed, and there was nothing after replication. But now there's this counterclaim, which only obviously starts here, because it can't start there, it starts here. Then there's a plea, then there's a replication, and now there's time for a rejoinder. So this is done, and this is done, but this isn't done. Are you saying to me, your suggestion is that for the main claim, pleadings have not closed, it will only close here. Close of pleadings is then delayed until the counterclaim is finalized. Is that what you think? Who agrees with that view? And the others then all say they close at different times, or you don't have an opinion. Who says they close at different times? No one. So the rest, so we have 2 opinions and 1. Okay, so you have to choose. Who says they close at the same time?
Perhaps
By show of hands. The case plan will certainly cater for when pleadings are filed, but it wouldn't cater for close of pleadings. It'll only set out the timelines. So it won't have a date saying, and then on 15 November 2017, pleadings will close. Yes, definitely. And they said, this will be filed then, that then. But the question is, do the pleadings for the one close at the same time as the pleadings for the other? I think perhaps the question becomes more pertinent, not so much from a procedural point of view as you've indicated, which makes sense because you have a plea and you have a counterclaim. These two are connected, and of course you can't have a situation where the one then proceeds to trial and case management while the other one's pleadings are still closed. But it really is that the one is just lagging a bit, waiting for the other one to get. So in my view, considering the rules and considering the authorities, I would say the main claim has closed and the counterclaim is not closed, so this one will wait for this one to close. Because consider for a moment I withdraw my main claim. What happens to the counterclaim? It remains a claim, substantive claim in its own right. It doesn't go away. So therefore you have two substantive separate claims. It's just that for convenience and from a logistical point of view, the rules allow a party to actually bring them together. But I'm not necessarily, I mean, this is my view on the subject, and that's not something that I know of that's been decided in our jurisdiction. But essentially, the importance comes in, I suppose, where it's important for a party to have reached close of pleadings. Say, for instance, one of the parties dies. Where are you? Now there's a liquidator. Are you before litis contestatia or after litis contestatia? So it becomes a relevant consideration. less often, because more often than not things run their course and all the pleadings are closed, and it doesn't matter which one closed when. But consider for a moment an instance, and there are such instances in law, where litis, and you can read up about the importance of litis contestatio to know whether litis contestatio has actually taken place. And in such an instance, it would be one of those where it would be difficult to decide if your thinking is that the main claim, the close of pleadings in the main claim, is subject to close of pleadings in the counterclaim, which inevitably usually would be longer, further along than the main claim. So, so that's why these things are important considerations. All right, the parties agree thereto in writing, and files same with the registrar. So the parties can write each other a letter and say, look, I mean, I think pleadings have now closed. And the other party says, yes, I agree. And then they write to the registrar a signed letter or a report or whatever to say, look, pleadings in this matter has closed. And then, of course, the court declares the pleadings closed. So believe it or not, parties can sometimes disagree, and it can sometimes be unclear whether pleadings have closed. But it's important to know whether pleadings have closed for a number of reasons, some of them being part of substantive law, but the most important and pertinent one for purposes of this course is that the matter continues here. So we can accept that we are done now with the pleading stage of this course, and therefore I can now safely say that you are now here. We are proceeding to pretrial procedures, case management, and interlocutory motions, which we will be spending the rest of this course on. Rule 51 says that it must be on application of a party. So court doesn't go around making orders just left, right, and center as it pleases. If there's a need for a party to have the pleadings declared closed, for whatever reasons, I don't think it is a procedural step that's often used, but there are certainly instances in which it is applicable, which is why the rule is there. The court doesn't go around making declaratory orders or whatever just because it can. The court will assume that a party has joined issue without alleging any new matter, or the last day, especially number 2. The last day for filing a replication or subsequent pleadings has expired, and no such pleading was filed. Now, an instance can arise where that has happened, one or two, option 1 or 2, where that's happened. But one of the parties have written to the other party saying, look, I need to replicate, but I need to consult my witnesses who are presently somewhere else in the world, and I'm only going to be able to consult next month or 2 months' time, and therefore I need time to file my replication. And then the other party says, no, pleadings have closed, and I'm going to make application to court to declare these pleadings closed. You may want to seek an extension of time as the defendant or the plaintiff to file a replication. The defendant says, no, I'm not giving you that. I'm going to apply to court to declare that the pleadings have closed. And then the court will need to weigh up whether it's going to grant the extension or declare the pleadings closed. It's part 6 of the rules, and it's Rule 53 to 56. We'll deal with that also, either today or tomorrow morning, and then how you apply for extension and sanctions and the like. Okay, good. So let's take a 5-minute comfort break, and then I'll get the new slides up and running for the second session. We're now done with session 1. Session 2 hopefully will go a bit quicker. It is now 9:32, so if you can be back here at 9:38. Thank you.